You know the outcome, but you really don't know how we got there. Welcome to American Esoterica. If history class gives you the metal toy airplane, this is the sound you make as you fly it around your living room. The essential stuff in between, the personalities, events, and other ephemera that shape our history and culture. I'm Brian Powers. There are two cases in particular that stand out among the Supreme Court's jurisprudence for their genuine awfulness. The court got the terrible ball rolling with the Dred Scott decision in 1857, but the icing on the institutional racism cake came down with the Plessy versus Ferguson case in 1896. We all know how that turned out. Segregation got the official seal of approval under the guise of separate but equal, undoing what, at that point, was 3 decades of federal attempts to undo the effects of slavery. It would take almost 60 years for Brown v. Board of Education to just begin to dismantle Plessy's harmful effects. And if you learned about this in history class, you probably only heard about the case opinion. And if you went any deeper, you probably learned that the case was brought by a black gentleman named Homer Plessy, protesting segregated train cars. It's kind of about that, but it's also really not. And it's way more calculated and maybe even cynical than you ever knew. Near the end of the Civil War and in the few years after, Congress passed a series of amendments, the 13th, 14th, and 15th, designed to right the wrongs of chattel slavery, which were then ratified by the states. While they ostensibly granted Congress expansive powers to eradicate the badges and indicia of slavery and thus promote equality, they ran up against a recalcitrant Supreme Court. This push-pull came to a head in 1883 when the court struck down an 1875 civil rights law. That law made racial discrimination and public accommodations a crime, prosecuting those who would deny the full and equal enjoyment of any of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement, subject only to the conditions and limitations established by law and applicable alike to citizens of every race and color. Denying Congress that authority, the Supreme Court essentially gave states, not the federal government, the means to enforce equality. Or not. First out of the gate to see how racist they could be was Florida, which passed a law in 1887 that required railroads to provide equal but separate accommodations for the white and colored races. Such cutting-edge racism caught fire throughout the South, which was eager to refight the Civil War in a new way. Sure, you may have your freedom, but we're going to make you feel our bitterness over it, and we're going to thwart your attempts to lead a normal life and participate in society at every turn. Soon, Texas, Mississippi, and then in 1890, Louisiana all had their own train segregation law. Louisiana's entry, the Separate Car Act, was particularly problematic for its black citizens, many of whom were something called free people of color, something of a third racial class centered in New Orleans who had enjoyed a similar social and political standing to white citizens. They were also known as the Creole people. In fact, New Orleans was generally an integrated city, even down to its schools and police departments. The new laws repressed all black citizens equally, however, and New Orleans activists decided to do something about it. They formed the Citizens Committee to test the constitutionality of the separate car law, better known as Comité des Citoyens, raising $3,000 to hire attorneys to fight the law. Of course, the best way to fight the law would be to have it overturned by the Supreme Court. So the attorneys would need to manufacture a test case that aligned with their strategy. This is where one of racism's more obvious effects played in their favor. See, racism may be a winning strategy for the stupid, short-sighted, and bigoted, but it's really bad for business. Railroads understandably hated the new law, which required them to run extra passenger cars to comply. It was bleeding them dry. So at least a few railroads were willing and eager to set up a test case to fight the system. Again, because racism was costing them big money. Now, all our committee needed was a willing participant, which sounds easier than it actually was. It had to be a genuine case with real stakes, including jail time. There could be true consequences for whoever they put through the legal ringer. Luckily, they found their man, and you may have already guessed his name, Daniel Day-Dune. Wait, you're saying, I do know this story. The guy's name was Homer Plessy, just like in Plessy versus Ferguson. You're telling it wrong. No, I'm not. The guy's name in the test case was Daniel Day-Dune, and he was put up to it by his father, Rodolphe, a member of the Comité des Citoyens. The guy's name in the test case was Daniel Day-Dune, and he was put up to it by his father, Rodolphe, a member of the Comité des Citoyens. On February 24, 1892, Daniel Day-Dune bought a first-class ticket on the Louisville and Nashville Railroad from New Orleans to Mobile, Alabama. He was arrested and charged with a criminal violation of the Separate Car Act. Things were going according to plan, until they didn't. First, the presiding judge and Day-Dune's trial disappeared completely. Just vanished, never to be seen again. Then, another setback came in the form of a Louisiana Supreme Court opinion on the same law. A train conductor was prosecuted for seating a black man in a whites-only train car, and the state's high court made a surprising ruling. The railway in that case argued that the law either didn't apply to travel between the states, or that if it did, it was a violation of the Commerce Clause. The state Supreme Court picked the first option. The law simply didn't apply to passengers traveling from state to state. The case against Day-Dune was therefore dismissed, as the new opinion meant the law no longer applied to him. The Comité des Citoyens was back to square one. They needed another willing defendant, and that is where Homer Plessy came in. A 29-year-old Creole shoemaker, Plessy had grown up in the integrated New Orleans, and like Rosa Parks to come, agreed to take the risk for a better future. On June 7, 1892, Plessy bought a first-class ticket from New Orleans to Covington, Louisiana, in the same state, and boarded the number 8 train on the East Louisiana Railroad. As the train started pulling away, the conductor walked through the train until he found Plessy sitting in a whites-only car. The conductor, J.J. Dowling, asked Plessy if he was a member of a certain race, which Plessy dutifully responded to affirmatively. The conductor then called for Detective Christopher Kane, who, with the help of some of the passengers, forcibly dragged Plessy from the train and arrested him on charges of violating the Separate Car Act. To the passive observer, it looked legitimate. Plessy was manhandled away from the train as a lawbreaker, and that was by design. Again, the stakes were high and the case needed to be airtight. Everybody was in on it, though. The East Louisiana Railroad agreed to the entire plan, and Dowling knew to seek Plessy out. It was no accident that Detective Kane was at the station either. He was actually a private detective hired by the Comité des Citoyens to arrest Plessy. They couldn't leave it up to someone else, who might merely arrest Plessy for something like vagrancy or trespassing or who knows what instead of a violation of the law they were trying to test. Before we get to the rest, we need to correct the record briefly, though. And we need to wade into what may be slightly uncomfortable territory. Because the weirdest part of Plessy versus Ferguson, at least the weirdest part other than that 7 ostensibly rational humans could find equality in enforced separation, is that Homer Plessy, the defendant at the heart of this landmark segregation case, was a white man. Mostly. Homer Plessy was 7/8 Caucasian. He had a single black great-grandparent. Under the racist one-drop rules in place at the time, it meant that Homer Plessy was considered to be black. But in outward appearance, Plessy could pass as white, probably because he was, again, mostly white. Daniel Day-Dune was similarly situated. In fact, it was the crux of the plan to begin with. The attorneys for the Comité des Citoyens realized that a moral argument about equality was unlikely to win the day, so they went shrewdly practical. It was one thing to demand segregation based on race, but without a workable way to determine race, train conductors were in the position of being racial arbiters, which would make the law arbitrarily applied. And why would arbitrarily applied laws be a problem? Because, basically, whiteness was seen as a property interest. The argument to the Supreme Court was essentially that Homer Plessy was denied due process as a white man, that he was entitled to given to white people. For every recognition, rights, privilege, and immunity, Homer Plessy was a white man. But this new law treated him differently, and in a way that was hard to do consistently. Well, that argument did not succeed. By a vote of 7-1, the Supreme Court, in the most insane case of twisted logic, decided that there were basically three realms of equality: political, legal, and social, and that the federal government only had the authority to police the first two. The states were free to set public policy. Laws that discriminate socially were A-OK, according to the court. The lone dissenter, Justice John Marshall Harlan, embodied a peculiarity all his own as a former Central Kentucky slave owner. But his dissent lit a fuse that smoldered for nearly 60 years before finally igniting the bomb that would very slowly blow Plessy apart in Brown v. Board of Education. He wrote, "In the eye of the law, there is in this country no superior, dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The arbitrary separation of citizens on the basis of race, while they are on a public highway, is a badge of servitude wholly inconsistent with the civil freedom and the equality before the law established by the Constitution. Why does it still seem so hard for others to figure out even today, any legal grounds? Justice John Marshall Harlan, a former slave-owning Kentuckian, figured it out in 1896, all with the help of a New Orleans shoemaker named Homer Plessy. This has been American Esoterica. All sounds are made by me, Brian Powers. Did I get it wrong? Did I get it right? Just want to talk about how ham-fisted my discussions of race are? Drop me a note. The address is yell@americanesoterica.com. More information on this show can be found at americanesoterica.com. Thank you for listening, and God bless America. Of the Comité des Citoyens. A member of the Comité des Citoyens. Comité des Citoyens. Comité des Citoyens. Comité des Citoyens. It's Comité des Citoyens.